When he was appointed to the Supreme Court in 1967, Thurgood Marshall joined a liberal activist bench that redefined American law. Over the next 24 years, he was the solid liberal vote that ensured abortion laws, protected civil rights, opposed the death penalty. Thurgood Marshall resigned today, the last true liberal on a conservative court that is certain to write its own chapter in American law. The impact of the Marshall resignation, tonight.
This is ABC News Nightline. Reporting from Washington, Ted Koppel.
Mark this as the end of an era. Depending on your political point of view, it is either the end of a long siege, during which the highest court in the land made public policy that set your teeth on edge for over a generation, or it is the end of a period of enlightenment in which the court served as the single most powerful counterweight to forces of oppression and discrimination. Either way, the retirement of Thurgood Marshall from the Supreme Court of the United States is the end of a long chapter and the clear beginning of a new legal and political reality. The trend has been years in the making, but liberalism on the High Court is out and conservatism is in. And that, at one point or another, is going to affect the lives of everyone in the country. We begin with this report from Nightline correspondent Jeff Greenfield.
I believe it's the right thing to do, the right time to do it, the right man in the right place.
When Thurgood Marshall became Justice Marshall in 1967, the headline was inevitable: the first black ever appointed to the United States Supreme Court. It was a storybook rise. The great-grandson of a slave who shot to the top of his law school class, then spent his life fighting official segregation. In 1954, as an NAACP attorney, Marshall's arguments helped persuade a unanimous Supreme Court to outlaw school segregation. They even made a movie about it.
What is important is that we get the principle established. Segregation by race is not legal.
And when Justice Marshall, now nearly 83, plagued by failing health, announced his retirement from the court today, it was this legacy that was recalled across the political spectrum.
The Supreme Court has lost an historic justice, a hero for all Americans and all time.
I have to tell you that Thurgood Marshall has left a lasting and strong and profound imprint on the law of this country. And with regard to civil rights law, no other person in this country's history has done more from a legal standpoint.
But there is another story here, one that is far more significant than the color of Thurgood Marshall or the color of his replacement. The tenure of Justice Marshall is a symbol of the slow, steady, all but certain end of judicial liberalism. The Supreme Court he joined nearly a quarter century ago, and the court he leaves today, have almost nothing in common. When Marshall became a Supreme Court justice, it was as a fervent member of a staunchly liberal majority. Chief Justice Earl Warren and William Brennan, both Eisenhower appointees, New Deal progressives Hugo Black and William Douglas, LBJ's Abe Fortas, they had helped shape a Supreme Court almost eager to strike down laws that did not fit their sense of what the Constitution required. Could states draw legislative lines that violated the one-man, one-vote idea? No. Could states permit voluntary prayer or Bible reading in public schools? No. Could criminal suspects be interrogated without being informed of their legal rights? No.
We have our legal arm, and we have our political arm.
Marshall joined this liberal majority wholeheartedly. In his time, the court opened the door for publication of the Pentagon Papers, found a constitutional right to abortion, upheld affirmative action, even ordered a president to release secret tapes. To some scholars, this activist court was a blessing.
This is the end of the era of the liberal court. It's true that Justice Marshall was alone on many issues after Justice Brennan left. The two of them were the last liberals who painted with broad strokes.
To others, it was a curse.
I am not sure that Justice Marshall, over his time on the court, has sufficiently taken into account that he is an unelected official and that the elected branches of the government ought to be the primary source of policy making in this country.
But whatever happened to that old liberal court? As Finley Peter Dunn once put it, The court followed the election returns. Today's Supreme Court is far more conservative, far less likely to strike down criminal laws and public policies of legislatures or the Congress. That's why the prospect of a new conservative justice alarms advocates of abortion.
The Supreme Court obviously is now stacked with people who do not see that the Constitution protects the right of speech with respect to abortion. So it does not take a wild imagination to think of the possibility that they would not see the constitutional protections for abortion.
That's why others cheer the prospect of a tougher outlook on criminal justice.
I think that the court today recognizes that while we may not abridge the rights of criminals within the criminal justice system, at the same time, the role of victims is a very important part of the system, and furthermore, that the role of the interests of society as a whole cannot be overlooked when we begin paying attention to the rights of criminals.
In later years, Marshall was an increasingly isolated voice of dissent on the court. His frustration, some called it intemperance, was on public display last year when Sam Donaldson asked Marshall his opinion of President Bush.
Let me put it this way. It said that if you can't say something good about a dead person, don't say it. Well, I consider him dead.
Who?
Bush.
Still alive, Mr.
You're
Justice.
damn right he is. I just don't understand what he's doing. I don't understand.
His absence now, liberals say, means that the court will no longer be a place of last resort for the powerless.
What you have to remember, and what Justice Marshall knew, is that there are some minorities who may never win in the legislature, and it's those minorities who most need an active court.
The debate has already begun about how much the question of race will or should play in the selection of Marshall's replacement. But politics, in the broadest sense, will be very much a part of that choice. Remember, Thurgood Marshall was the last justice appointed by a Democratic president, and that was 24 years ago. So more than a decade after conservatives captured the White House, the Supreme Court is now solidly theirs. And no matter who wins the White House in 1992 or 96, that conservative domination will run well into the next century. I'm Jeff Greenfield for Nightline.
Nightline is a presentation of ABC News. More Americans get their news from ABC News than from any other source.
From ABC News, this is Business World with Sander Van Oker and Stephen Ogg. Now from New York, here's Sander Van Oker.
This is the week for some big prizes. For the entertainment industry, tomorrow night is Oscar night, the Academy Awards, the culmination of a year of movies. And in business, it's what might be called the mother of all proxy battles, the vote on Thursday on AT&T's hostile bid for NCR. But as business editor Stephen Ogg reports, for those who hold stock in both companies, who wins and who loses is not as simple as the contents of the envelope, please.
It's just like a World Heavyweight Championship boxing match. The arena may be different, and instead of two heavyweight boxers, the fighters are two heavyweight corporations. The winner's purse may be worth more than $6 billion. And the odds on AT&T winning its fight for NCR?
There is a 100% chance that AT&T will elect 4 directors. That's 100%. But can AT&T muster more than 80% of the votes? I don't give them that chance.
Maybe it's an 80% chance of getting an 80% vote, but that's it's not quite, the odds aren't quite that high.
For AT&T, the stakes could determine its future in the computer business. Reportedly, they've lost $2 billion in it so far.
We're looking to build for a long period of time. We want NCR to be our computer business and to take advantage of what we bring to the table, which is the best networking capability in the world and one of the greatest laboratories in the world.
To accomplish this, AT&T has launched a proxy fight. Either it gets 80% of the vote and wins the company, or with a bare majority, it gets 4 seats on the NCR board of directors. Allen says that would put pressure on the remaining 8 NCR directors to make a deal.
I can tell you I would not want a third of my directors elected to my board without my consent and over my objection. I can't imagine that the other surviving directors would be very comfortable in that situation.
But NCR Chairman Charles Exley says his directors will still control the company.
Well, I've looked at the candidates they've put up. These are not four thugs that they've nominated, and I presume these people will conduct themselves in a suitable way.
About 2/3 of NCR stock is owned by institutional investors, like pension funds. Those who run the funds say their decision is more complicated than simply whether to take $100 a share for their NCR stock.
We are not arbitrageurs. We're in this market for the long term. It's no accident that we own both of these companies. You know, they're both good, solid companies, and our portfolios consist of most of American industry. And so our concern is that these companies thrive and do well. And so the issue in front of us really is this merger going to make these companies better, or is it not?
As we decide just exactly what we're going to do as the vote comes and the tender comes, is to understand just exactly where that long-term value is. I guess at this point, my view would be that it's under the AT&T umbrella.
To help institutions decide how to vote, a whole new cottage industry has grown up, like Falk & Company of Atlanta. All the result of a Labor Department ruling that pension funds must vote their shares and justify the votes. Falk's firm of 19 people charges for advice by the number of different companies represented in a fund's portfolio. The average fee runs about $25,000.
What we try to determine, if passed on that company's ballot, what is the economic impact it will have on that company, and what's the impact it will have on the value of the underlying shares.
Nell Minow of Institutional Shareholder Services of Washington, D.C., which offers similar advice and charges a similar fee, says the AT&T NCR fight is so different, her firm is giving very different advice.
In AT&T and NCR, we did something we've never done before, which is that we gave two different kinds of advice based on the individual portfolios. We think that the deal is good for shareholders of NCR and bad for shareholders of AT&T. So based on the mix in the individual shareholders' portfolio, we advise them either to vote for it or to vote against it.
So an institution whose AT&T holdings are at least 5 times the market value of NCR holdings would vote against the merger. Why is it bad for AT&T?
Because we really haven't seen any evidence that they can run NCR any better than NCR is running itself, or that it provides the kind of significant synergies that would make a heavy investor in AT&T do well.
The AT&T NCR fight is far different from the big deals of the 80s. It's not a corporate raider on a break-apart, destroy-the-company acquisition. It's a bid by a blue-chip company. And it may be a harbinger of the 90s, now that the end of the junk bond market has dried up financing and knocked most of the individual corporate raiders out of the ring. Sandy?
Thanks, Steve. That's it for this week. Whatever business you're in, we hope the week ahead is a prosperous one. I'm Sander Van Oker. On behalf of everyone here at Business World, thanks for being with us.
Business World is a presentation of ABC News. More Americans get their news from ABC News than from any other source.
From ABC, this is World News Tonight with Peter Jennings.
On Capitol Hill tonight, the House of Representatives has begun voting on several versions of how the U.S. should define civil rights on the job. The Democrats' plan would make it easier, or less difficult, for minorities to win job discrimination suits. The Republicans claim that would force companies to set aside a certain number of jobs for minorities and women. In a word, quotas. Here's ABC's Cokie Roberts.
The civil rights debate that's been raging outside the Capitol came inside today, where Republicans repeated the now familiar charge, it's a quota bill.
Even worse than just a quota bill, if you hire by quota in this bill, you face a lawsuit. If you don't hire by quota, you still face a lawsuit.
Democrats have been unable to tear off the quota label despite specific language in their bill deeming the use of quotas an unlawful employment practice.
Mr. President, read the bill before you hit the road. This is not a quota bill. It specifically outlaws quotas.
Calling this not a quota bill reminds me of an old Italian saying.
Though you dress the shepherd in silk, he still smells of the goat.
Republicans claim that other language in the bill will prompt employers to hire set numbers of minorities and women rather than risk discrimination lawsuits. Democrats counter that this debate has nothing to do with language and everything to do with running for office next year.
Even if this bill were the Quota Abolition Act, the White House would still say it's a quota bill.
No one can say with absolute certainty whether this civil rights bill would encourage quotas if it became law, but for it to become law, Congress would have to override a threatened presidential veto. So far, Democrats have been unable to attract the 2/3 vote necessary for an override because members fear the quota label, valid or not. Cokie Roberts, ABC News, Capitol Hill.
That's our report on World News Tonight. I'm Peter Jennings. See you tomorrow. Good night.
This has been a presentation of ABC News, where more Americans get their news than from any other source.
From ABC News, this is Business World with Sander Van Oker and Stephen Ogg. Now from New York, here's Sander Van Oker.
At last, some good news for the real estate business. This past week brought word that February saw the biggest upswing in both sales of new and existing homes in 5 years. And those reports came only days after other upbeat news. Housing starts in February showed their biggest gain in more than a year. And February application for building permits showed their first rise in 8 months. But even as the market shows new signs of life, real estate sellers are facing new obstacles such as regulations from the government forcing landowners to clean up their acts. That can be tough on a homeowner who finds an old oil tank under his front lawn, even tougher on those with commercial properties.
I suggest pre-acquisition site assessments to virtually every client who is purchasing non-residential property. And in some instances, when I have a client who is purchasing property for future residential development.
The Superfund laws say that if you own property and it turns out to be contaminated, you can be responsible for cleaning it up. And this is having a major effect on the real estate market.
Any prudent lender has to check the collateral that he's accepting for a loan. And to check the collateral, which is frequently real estate, in today's environment, you have to check out the property and make sure that there are no hazardous substances or any sort of discharges.
After a court held a bank responsible for a cleanup of property where it held a mortgage, banks are now unlikely to lend money against contaminated property, especially when cleanup costs can well exceed the property's value.
Hydric soil conditions, which means that the soil is saturated for sufficient amounts of time.
The demand for environmental evaluations has created a new cottage industry for business. Today, roughly 500 firms nationwide do assessments, from small consulting firms specializing in assessments to large nationwide environmental engineering firms that do everything from assessments to cleanup.
You look for characteristic signs such as stressed vegetation, stained soils, improper waste disposal areas, problems related to drainage, to runoff that could actually either impair that property or off-site properties.
See if it's less saturated, maybe a little bit more sandy.
The firm that handled this site assessment was ATEC Associates, a nationwide environmental consulting firm. In the physical inspection of the property, the engineers and biologists found no apparent pollution or dumping. Questions, though, were raised outside an office building property ATEC assessed in Virginia.
It's got a slight oil smell.
That may mean additional water and soil testing not included in the usual $3,000 to $15,000 fee for a site assessment. Inside everything from the water treatment system to the pipes were scrutinized for hazardous contamination. Even the interior design may be a potential source of problems.
Within a building, you have to look for asbestos-containing materials. You can evaluate the floor tiles, the ceiling tiles, wallboard, and even the carpet in the building could be a suspected area of asbestos-containing materials.
In addition, site assessments research the history of the property, evaluating its past usage through title searches, government records, aerial photographs and topographical maps. Site assessments generate an estimated $600 to $700 million for environmental firms. But that isn't where the big money is.
If there's a problem, if there's contamination that's found, the company then will proceed into phase 2 and phase 3, the remedial investigation feasibility study, which may be anywhere from $25,000 to $100,000, and then it's got to be cleaned up, which can run to millions of dollars.
With no industry regulation, no licensing, and no standard formula for an assessment, it's client beware, and that leaves some industry groups concerned.
There's been growth by virtue of demand. The demand has been placed on very qualified firms, but they themselves are not fully capable of keeping up with everything that's needed, and this has created the opportunity for fledgling organizations that really are not fully competent to do what they claim they can do.
Banks have little protection when they foreclose on polluted property, and they don't think that's fair.
We're not environmental consultants. We are trying to be good corporate citizens for the environment, but we're bankers. So to place us in blame when we've done everything that we think we should do before we issue a loan and still be possibly held liable, that's an unfair statute.
In many cases, a deal involving contaminated land can still be salvaged with the parties allocating the cost of cleanup. But in a worst-case situation, the deal could wind up in the dumpster itself if the purchaser decides not to buy or the bank decides not to lend. This week's Business World guest is the Vice President who covers environmental management areas at the research and consulting firm of Arthur D. Little. J. Ladd Greeno joins us from our studios in Boston. Mr. Greeno, the environmental movement has been with us a long time, but do you think that businesses and consumers understand the full, I repeat, the full implications of what this movement means?
No, I certainly don't. I think we see that a number of business executives are beginning to appreciate the costs that are involved, the opportunities that are involved. Certainly society in general puts a premium on environmental protection, but as to how it affects their lives and what it means, I think it's not well understood.
The Congressional Office of Technology Assessment assesses the cost of cleaning up our problems at $100 billion. Who will pay for it?
Well, ultimately, we all will in terms of society. The implications for businesses are that the laws in not only the United States, but North America and increasingly throughout the world are such that we're going to find those with the assets are going to pay. And that's the way we see the world moving.
But is it fair? Is it fair for someone who sells a property, someone who buys it, the bank who lends the money, to be responsible for what may not be known?
Well, fairness is a difficult issue. I think that what is fair to say is that the public is expecting there to be much higher environmental accountability, and we've got a performance problem. We do have $100 billion, as you say, in potential cleanups just here in the United States. Some estimates are double that, $200 billion. We see the same kinds of costs throughout the world.
We now, or the administration, would like a free trade treaty with Mexico, but a lot of congressmen are saying, and they have their other reasons too to protect their own constituents, that environmentally Mexico is not up to speed with the United States. Is that a fair charge to make against Mexico?
I've worked in many countries. I have not worked personally in Mexico. I can say that generally there are a number of countries that are not up to par with the United States, but what we see is a heightening of environmental awareness and environmental protection really around the world.
All right. If businesses don't, as you said before, fully understand the implications of this, there are businesses who do understand that there's strategic advantage to this, is there not?
There are indeed, and there are a number that are looking for how they can position themselves as this growing environmental accountability takes place in their businesses, not only from a liability, not only from a court and a regulatory enforcement, but importantly in the marketplace. They're expecting that the consumers are going to vote with their shopping carts. We haven't seen much of that yet, but I think we're going to. It's going to be a very exciting time for those who are charged with environmental responsibilities for their companies.
Do you run into resistance when you advise corporations that this is good business in the long run, maybe even in the short run?
Oh, certainly there is resistance.
but we're finding a large and growing number of companies that don't need any convincing of it. They're more looking for what's the issues for them, how do they posture themselves, what's the right timing. You certainly can spend an awful lot of money in the environment, perhaps before the marketplace will value that.
But quickly, would you say that it's money well spent, it's bread upon the waters?
I think it will be. I think that the situation is such already that indeed this accountability is going to start taking effect.
Thank you very much. Thanks for joining us here in Business World.
My pleasure.
That's it for this week. Whatever business you're in, we hope the week ahead is a prosperous one. I'm Sander Van Oker. On behalf of everyone here at Business World, thanks for being with us.
Business World is a presentation of ABC News. More Americans get their news from ABC News than from any other source.